First case of the morning is State v. Pursley. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
Your Honor, I'm going to defer my argument to Attorney Marie Nicola in my office, and she'd like to reserve 5 minutes.
All right, very good. So you know, we will be keeping time on the thing over there too. I think it's your left. You will be the top clock initially. I will not use the bottom one at all for rebuttal, so if you go 11 minutes, you'll see 4, and any time you go over will be the time you have left for rebuttal. I'll try to give you a reminder of 1 minute left, and I'll do the same for you, counsel, as that will be. And of course, you know you're the middle time up there. The arguments are being recorded, both visually and audio recording. So when you come up, please stay behind the podium so we can see you and speak loud enough so we can hear you. If you have the use any victims or minors or anyone, please use initials or terms such as victim or neighbor or something like that. Don't use the name of the individual if you can avoid that. Having said that, we've read your briefs and ready to proceed in that brief.
Good morning, Your Honors. I'm Marie Nicola. I represent Eric Pursley. I'd like to reserve 5 minutes for rebuttal. Our brief outlined 3 assignments of error for this court to consider. I'm going to jump into the first assignment, focusing on the manifest weight of the evidence. I know this court's read the briefings and is familiar with the record. Our briefing had a pretty lengthy statement of fact, but I want to highlight the facts that Your Honors, sitting as the 13th juror, need to hear to realize that this case truly is the exceptional case, warranting this panel to right the wrong that took place in the trial court. Eric Pursley rented an apartment from the victim, in this case DS, and his wife. The apartment was in Akron, Ohio, but DS and his wife resided in California. They came to those properties rarely. On October 5th, 2022, Eric was in his apartment with his fiancee and their infant child when DS arrived unannounced, knocked on the door. Eric was not expecting his presence there that day. DS was angry and argumentative. He was arguing about back due rent that he believed he was owed. Other people in the building heard an argument. The state's brief argues that this demeanor would have been out of character for DS based on his wife's testimony that she knew her husband to be a softie with tenants. The court should note that in that same testimony, DS's wife stated she also knew her husband to become argumentative, persistent, frustrated, and worked up, and that's the demeanor he presented to Eric on that day. Eric and DS were facing each other in a very tight and confined area. An officer at trial testified that fitting 2 people in that area would be tight and be difficult. DS stood at about 6 foot 1 inch, weighed around 222 pounds. Eric is around 5 foot 4 inches and weighs around 150 pounds. So as the argument escalated, with DS towering over Mr. Pursley subjectively believed that the demeanor of DS was threatening and unrelenting, and he warned DS that he did have a lawfully owned firearm and he would use it to protect himself if DS did not calm down and back off, step away. In response, DS reached for Eric's throat. Obviously, the state of Ohio recognizes strangulation as a criminal offense. It's nothing to take lightly. In response to that, Eric fired 1 shot at DS, which unfortunately was fatal. After the sole shot was fired, Eric disarmed his gun, placed it on the floor, called 911, and reported these exact facts to dispatch. The evidence is clear that Eric acted in self-defense on that day, and the law is clear that Eric was permitted to act in self-defense. The evidence that was presented at trial by the state of Ohio does not change that final conclusion. The jury clearly lost its way in finding that the state did not disprove self-defense. So added to this were the clear deficiencies in trial counsel's assistance. Our brief lays out the facts and the arguments for this assignment pretty thoroughly. I want to just touch on one thing for this court to consider when making its decision. The state's brief points to information discussed in our brief and considers it outside the record and therefore shouldn't be considered by this court. I think the fact that the information is outside the record and was not presented to a jury speaks to the ineffective assistance of counsel claim that we are arguing in our brief.
The only issue with that, though, is it's your burden to show prejudice. So how do we see the prejudice without knowing what was, without having that in the record? is what I'm
Sure.
saying.
So I think that to chalk every decision made by trial counsel of his strategy, I think just fails to ignore the human truth that sometimes mistakes are made. And a trial counsel has the obligation to efficiently investigate a case and determining what kind of defense to put on. In this case, there were multiple police officers who referenced witnesses that were in the building, other tenants who had had previous run-ins with DS, all of those types of things that speak to and give credibility to Eric's testimony. He testified in his own defense, and he was the only witness to testify for the defense. So any evidence, anything that would have given credence and credibility to Eric's testimony would have been beneficial, and failing to do that prejudiced Eric.
But without, to follow up to Carr's question, how do we know that's beneficial? If it's not in the record, how do we know it's beneficial? We don't know what they would have said.
Right, I think that in our brief kind of goes through what we believe would have been said by his fiance, by the other people in that building, and I think it would have been beneficial for anything that Eric testified to have been credited.
I take it there's no proffer on the record or anything saying witness so-and-so would have said X, Y, and Z,
Correct.
had they been called.
Correct, so there, and again, I think that speaks to the ineffective assistance of counsel assignment. This leads me to the last assignment of error, which is the trial court's premature reading of the Howard charge. Again, I would argue that the court being limited to a plain error review kind of speaks to the ineffective assistance claim because trial counsel did not object to the premature reading of the Howard charge. Under these specific circumstances, I believe that speaks to the ineffective claim as well. As the state's brief pointed out, it is not an abuse of discretion to read the Howard charge after being notified by the jury that it's having difficulty in reaching agreement after deliberations. I think that's the Moffin case. After deliberations, by definition, means that the jury has finished deliberating. Here, the jury specifically asked to return the next day to continue deliberating. The foreperson expressed a struggle in reaching a verdict, but that cannot be held to be synonymous with being unable to reach a verdict. Every jury struggles in reaching a verdict. That's the name of the game. But that does not mean that they were unable to reach a verdict. In fact, they asked to continue their deliberations the following day so that they could reach a verdict. So reading the Howard charge prematurely affected Eric's substantial rights because not allowing a deadlocked jury to occur deprives the defendant of tactical tools that can be used to secure lesser charges, have charges dropped, or an opportunity to obtain a more sympathetic jury pool. This court's previously outlined the goals of supplemental jury instructions and the balance that the trial court has to weigh in deciding when to read that charge. Including in that balance is that the charge must leave open the possibility of a hung jury and resulting mistrial. In this case, the trial court read the Howard charge prematurely to prevent a hung jury and to prevent a mistrial. The right to a mistrial without a unanimous verdict is crucial in the pursuit of justice. And while I understand that decisive rulings are preferable, to imply that a hung jury has no place in the legal system is dangerous. The last fact, unfortunately relevant fact in this case, can't be ignored, that Eric is a black man, Diaz was a white man. Numerous studies have been conducted, I cite to those studies in the brief, about the implications that race has on stand your ground laws as they pass throughout the United States. The most telling of those studies, again, which is cited in the brief, shows that when the shooter is white and the victim is black, the rate of justifiable homicide is 34%. When the races are reversed, the shooter is black and the victim is white, the rate of justifiable homicide fell to 3%. I believe this evidence strongly suggests and shows that white assailants can more confidently use deadly force when their victims are black than black defendants can when their assailants, when their victims are white. Again, black lives, whether they belong to the victim or the defendant, are not treated equally under the law. The stand your ground law carves out situations to justify homicide in certain situations, and the situation Eric Pursley found himself in on October 5th was that exact situation. There is now an opportunity for this court to meaningfully and properly address how the stand your ground laws in Ohio were meant to be interpreted and how they should be interpreted moving forward in the 9th District. If there's no questions, I'll reserve the rest of my time for rebuttal.
Seeing none, thank you.
May it please the court, Helen DiMartino, on behalf of the state of Ohio, the appellee in this case, we are asking that this court affirm Mr. Pursley's convictions for murder as well as felonious assault because they are supported by sufficient evidence, the manifest weight of the evidence. He received effective assistance of counsel, and the trial court did not err in giving the Howard charge at the time that it was given. The defense is asking this court to ignore the evidence that was presented at trial and to only focus on the self-serving statements that were made by Mr. Pursley. There's no dispute in this case that Mr. Pursley, at close range, fired a gun, striking his landlord in the neck, head area. He indicated the same on 911. That has been his consistent version of events. But he does leave out, at least in his appellate argument, the evidence that was presented at trial, which showed that the victim did go to the apartment that day on 657 Sumner Street, which was a single home that had been converted into 4 apartments. The police did speak to the 3 other tenants as well as to the maintenance man who was in the basement that day. Sergeant Stravaji testified that after speaking to the tenants as well as to the maintenance man, there was no evidentiary value to what those folks had to say. Some heard maybe some arguments and some heard a gunshot, but nothing else of value. The idea that someone who's renting, when their landlord comes to talk to them about the rent, can make an argument that they're not gonna pay the rent because of some reason that they have created that hasn't been litigated, that is maybe something that you could argue is a breach of contract. It's not a basis for self-defense for using deadly force. The defendant...
Counsel?
Yes.
Wasn't the jury charged on self-defense?
The jury was charged on self-defense, so I'm just gonna go to
So
that.
they just met,
Mhm.
so then the judge determined that they met I can't talk today, I apologize.
They met their burden.
They met their initial burden of going forward.
I agree. So to disprove that and to show that he wasn't at fault in, that he was at fault in creating the situation, is what I was getting at, so I'm sorry, but.
I'm sorry for interrupting you.
So with regard to that, the defendant acknowledged that the victim didn't have a gun, the victim didn't have a knife, the victim never made contact with him. So he was trying to make an argument that there were mice or drug issues at the apartment, and when the landlord came over, there was allegedly an argument, which the only version of that would be what he articulated in his statement, that was the reason why the victim, who the wife testified was a softie, who gave folks multiple opportunities to get caught up with the rent, and in fact had given this defendant time to get caught up with the rent. He had been $3,000 behind before. He was behind again. There was a note in the victim's car indicating that Mr. Pursley's rent was $710 a month. He was behind since August. This was October. He had blank 3-day notices, and he had a note that said, quote, 3-day notice, question mark. The police found on the landing a 3-day notice that was completed. They found tape, which would have been used to put the notice up.
Counsel, I wanted to make sure I understood that as well, because everyone kept saying completed. By completed, does the evidence reflect that they actually had the victim's name and, not the victim, the defendant's name and address and everything already on there?
It just says completed in the record, so I don't want to add to it.
Was it put into the record, the notice itself?
I believe the notice
So it's
itself is in
exhibit.
the record. I believe it is an exhibit. So that was in the record as well. So while
The reason I'm asking is because that seems a little inconsistent with some of the testimony then too, that he was a softie and had no intention of throwing him out. The wife testified he had no intention of throwing him out, all those things, but yet the state seems to be arguing that he went, the landlord went there with the intention of evicting him.
the wife testified that she did not know if he was going to go over there that day to execute a 3-day notice. She didn't say she knew for sure. She did specifically say that she was aware of no formal complaints, which this is all kind of speculative and red herrings and things to kind of, they want to bolster the defendant's credibility by saying that he had ineffective assistance of counsel because counsel should have introduced evidence that maybe there were mice or drugs, that really is irrelevant to the situation. If the landlord came over for any reason and said, you're behind in the rent, I want you to pay, even if he said it strongly, it's not a basis, to shoot him in the throat or to say, I'm not gonna pay you because of maybe there were mice, maybe there were drugs. There's no evidence of that. The wife clearly said there was no formal complaints, and if there had been complaints about rodents or anything else, they would have used the pest control company that they have a contract with. So all those things.
And I agree, a lot of that are all red herring, and what's going on, was there an issue or not. But
Mhm.
ultimately, at the end of the day, if in fact the victim grabbed Mr. Pursley by the throat and tried to strangle him, would that be a basis for self-defense?
It could be, but there's no evidence. He admits, the defendant himself says he never made contact, so he was never strangled. This is a perception that he created, allegedly. So there is no
So that
evidence.
in your view, the record, it would indicate that the defendant said, I was never strangled by the homeowner.
Correct. He indicated that there was never contact, and he tries to use the same autopsy photos that he says it was ineffective to introduce them. He says those same photos bolster his claim that the taller victim was crouching over him in an attempt to strangle him. So
Does the defendant say that he approached him or reached out for him or anything, or is the defendant testimony that the victim was just standing there and was shot?
he said he had to do a little scoot, I think was the word he used, to avoid him coming at him. But he says clearly that he never put his hands on him, that
Well,
he didn't have a weapon.
I'm sorry.
Mhm.
Counsel, I guess that was one of the reasons why I was asking about what evidence was actually submitted in regard to self-defense, because again, it seems like you're arguing, really, there's not even any evidence submitted in self-defense, he just shot him.
Correct.
And that's not what the judge found, obviously.
The judge found that they had made enough to reach their burden.
Right.
But to go to that issue of, we have to disprove any one of those three. So at first, we're saying he was at fault in creating that situation. If the landlord came to the door and demanded rent and wasn't armed, there's no evidence that he ever touched him. He could have gone, back into the apartment. He certainly could have used force other than shooting him in the head when he's not armed. And the evidence is clear that even if he sometimes gets a little worked up, that he's a softie. He gives multiple chances, that him acting in this way to allegedly want to strangle somebody at the door is completely inconsistent with his character. That would negate that first prong of self-defense. There's also no evidence that he had a bona fide belief that he was in imminent danger of death or great bodily harm.
So when he testified that because he was almost nearly a foot taller than him, and probably 100 pounds, that he felt that he was in imminent danger because the guy was coming at him, and he had told him to back off several times. That's what he testified.
That's what he testified to, which is up to the jury to decide if that's credible or not.
Right, so all that was testified to. So are you saying to actually, that the state does not have to present evidence? I guess I'm getting this all confused in my mind, let me think it through for a second. So I feel like we're still going back to the burden switching back and forth again, because it gets a little complicated, but the point is, are you saying that he would have to demonstrate that he actually touched him before? Because you made that point with Judge Stevenson, that he hadn't laid hands on him. Is he supposed to wait till he starts strangling him, then, or get the gun from him?
I think it depends on the facts. Here, what I'm saying is that his testimony was not credible. It wasn't consistent with what the tenants heard. It wasn't consistent with the typical behavior of the victim.
What did the tenants heard? Some of the tenants testified, others did not.
So this is what the officer testified as to what the investigation showed, which is why they said none of the other tenants, I want to use the word, statements, I guess, to the police had any evidentiary value, because they didn't hear anything specific. They maybe heard some arguing, and they heard a gunshot, and that was it. So they didn't hear, this alleged, this is your day of reckoning, and all the statements that the defendant said he made. So if the state can show that the statements by the defendant are self-serving and lack credibility, then that's sufficient, is what I'm getting at. So, under a different set of
Can we read
circumstances.
anything into these people not being called to testify? I mean, that's, the most, I think, if I understand you, we have hearsay testimony from the officer saying, I
Correct.
talked to these people and they said I didn't hear it.
Correct.
That's all hearsay. How can we read anything into that?
The defendant himself also said no one else saw it. So there's no indication that there was
No one
any.
saw, but not heard.
Right, there was no indication that anybody else saw it. As far as what they would have heard, if we had, you know, if the police had done an investigation and the other tenants had said they heard something, whether it was threats or whether it was consistent with either side, the state would have introduced it. So I don't take anything into it being, you know, one, we proved our case the way we proved our case and we're entitled to do that. But the defendant could also have, you know, talked to those tenants as well. For us to
that's
have,
nothing they're doing, they're saying it was ineffective assistance of counsel.
but they're not saying what these tenants would have said. There's no indication that the tenants heard anything other than maybe some noise, not threats, not the type of specific things that the defendant is using to articulate that this was self-defense. And ultimately, it's a question for the jury, for them to decide the credibility of the witnesses that testified, weigh the evidence that was presented at trial, and then look at what the defendant said and say, does that sound like a believable version of events? And here's-
Which gets us, I'm sorry, I know you're running out of time,
Mhm.
which gets us to the last assignment of error. In regard to, did the trial court prematurely give a Howard charge?
So the state would argue that it was not prematurely given. The court indicated that the jury had said they were at a stalemate. And the issue that was raised was more of, is stalemate, you know, interchangeable with the word deadlocked? And here, the jury, the court said after 8 hours and we've reached a stalemate, that is sufficient for a deadlock. And then there was no further, you know, objection or issue with the charge being given. The state would argue that the trial court did not abuse its discretion, which is the standard that we would look at, for giving the Howard charge at the time that it was given, that a stalemate and deadlock are interchangeable, and under the facts of this case, after that many hours of deliberation.
Like you said, under the facts of this case, but so the facts of this case also demonstrate that after the foreman said there was a stalemate, the jurors indicated that they wanted to deliberate some more.
Mhm.
And then the foreman said, you know, we're not gonna reach a verdict today, but we'd like to come back tomorrow and deliberate. So it seems like they were kind of pulling back that indication that they were even at a stalemate.
And the judge took that to mean, right, that they were still at a stalemate, and that was the judge who listened to them and saw them. That is absolutely in the record, and if this court wants to, you know, interpret that as an abuse of discretion based on that statement, you know, I'm not gonna argue with you that that's what it says in the record. It does say that in the record.
What
but-
about in the record that the court said she didn't want there to be a hung jury, she didn't want to try the case again?
Right, I don't think that's a basis for why she gave the Howard charge. I understand that she said that, but she was giving the Howard charge because she found that they had said they were at a stalemate and used that term interchangeably with deadlock. I do understand that concern about not wanting to try it again is not a proper fact to use when you're making a determination on
And
whether or
I
not to
guess
give it.
the judge also made the statement to the effect that they've been deliberating longer than the trial took. What relevance is that?
It isn't. I would agree it's not relevant to whether or not to give a Howard charge. Based on the evidence that's in the record and the fact that it is up to a jury to determine the credibility of witnesses, the state would argue that it proved beyond a reasonable doubt that Mr. Pursley acted with purpose that day when he used his firearm to shoot his landlord, who was unarmed and had made no contact with him, outside the door of the apartment that he rented. He was behind in his rent. I know they argued it was speculative during their argument here today. It was not speculative. The defendant conceded he was behind in his rent. He tried to say that it was because he felt he didn't have to pay unless the living conditions were as he wanted them to be, but there's no evidence that those living conditions were not anything other than fine. There's just nothing in the evidence.
A little less than 1 minute, counsel.
And we would further argue that the evidence supports the fact that he was represented by effective assistance of counsel. You don't have to introduce evidence that's not relevant, that wouldn't show prejudice. And we would further argue that the Howard charge was given at the proper time. Thank you for your time.
Thank you.
back to some of the things that were addressed by the state. I might jump around a little bit, so excuse me. The state noted that that DS rather was not armed. I think it's important to note that Eric did not know whether or not DS was armed. The law is a subjective belief, and Eric, with DS standing over him, towering over him, aggressive and angry. Eric was not very familiar with DS because he lived in California and did not visit the properties often. The height and size difference, the fact that DS did not relent in the presence of a firearm. Eric had his firearm, which I would also like to note was lawfully obtained. He went through the range 42 in Barberton, got his CCW, took the certification classes for stand your ground laws, and acted in accordance with that training.
But the state is saying, okay, all that was testified to, but the jury just didn't have to believe the defendant, because there's nothing that says that the jury has to believe that he claimed or that he did actually tell him to back off, and I've got a weapon and I will use it to defend myself if I have to, all those things. They don't have to believe that. What are we to do with that?
I think that now goes to the manifest weight of the evidence. This court now, as the 13th jurors, have the opportunity to give credence to that testimony and to the facts that we're presenting and consider it and apply it correctly to the law and to the self-defense defense. So again, the argument that DS was not, that DS was not armed really doesn't have much merit, because it's a subjective belief, and even if mistaken, the benefit of hindsight doesn't help Eric in that moment when DS is towering over him, unrelenting.
But it still has to be reasonable.
Correct. And I think that in Eric's mind, again, in this situation, this small confined situation with this man at his door, with Eric's infant and fiance in the apartment, he reasonably believed that he was in danger. He testified that that DS reached for his throat, and that is what caused Eric to fire the shot. The medical examiner's testimony, she was the only expert to testify at trial. Her conclusions and her findings support that testimony, that he was reaching for Eric's throat. She testified that when determining the path of the bullet, she assumes that the individual is standing upright. In this case, as the state pointed out, the bullet hit DS somewhere above the shoulders, indicating that DS was in a crouched position and was not just standing there, standing upright. Had he been standing upright and not advancing towards Eric, then the bullet would have hit lower, about almost a foot lower than it did. The Howard charge, I think the state, and you commented on it, that it was read after the trial court mentioned that the jury had been deliberating longer than the case had been tried. I think law has established that the time that the jury deliberates versus the time that the case was tried is not relevant, doesn't matter. In terms of why DS was there that day, I know the state commented about unpaid rent. I think we all know that it's not stand your ground unless you owe rent to your landlord. There's not an exception carved out there's not an exception where Eric, because he was arguably behind on rent, was then stripped of his right to act in self-defense. The fact that DS was there, and actually, let me revert back. So the state also argues about the 3-day notice, and I think that maybe an attempt to say that Eric maybe wasn't lawfully in the apartment, or that he was the one that created the situation. Legally, and I think the state concedes, legally, when no 3-day notice is posted, Eric is not evicted. So being behind on rent doesn't equal not allowed to be in the apartment. And there's
Counsel, I'm not sure I understood the state to be arguing that. I think they were arguing that the landlord wanted to post it, and he shot and killed him to prevent him from doing it.
Yes, okay, so if that is what the state's argument is, I would argue that the evidence in the trial and all the testimony presented refutes that. His wife, the DS's wife, testified that any time a 3-day notice was gonna be posted, she was aware of it. She testified she had no indication from DS that he was going to serve a 3-day notice.
Let me ask you, the exhibit that was admitted into evidence of the 3-day notice that they found on the steps, was that, when everyone keeps referring to it as completed, does that mean that the defendant's name was on it and his address?
It's my understanding that there was a blank 3-day notice with no information filled out that was found in the victim's vehicle. With the victim found on the staircase or around the victim's body was a template or like a ledger that he kept with the tenants' names, and next to Pursley's name, it said 3-day notice ? Is my understanding of the record.
Thank you.
All of that said, regardless of whether, and I don't believe there was a 3-day notice filled out, but even if there had been, if it had not been posted on the door, then there was no eviction notice, and Eric would have no way of knowing that there was an eviction 3-day notice that DS was threatening to post, because there was not one with DS.
And counsel, your time's up, you may briefly conclude.
All of those things considered, I think that this court has a great opportunity to interpret the stand your law ground, and we'd ask the court to reverse. Thank you.
Thank you, and thank both of you for the presentation this morning on behalf of the court. The court will take the matter under advisement and issue a decision in due course. That decision is released, will be mailed to you by the clerk of court, and also be available on the High Supreme Court website.
Thank you.
Thank you.